Mrs. Morris owned a long white mink stole. She took the stole to a furrier to have it cleaned. He sent it along to C.W. Martin and Sons, who were specialty cleaners. They had a special room for cleaning white furs. A young employee, Morrissey, who had worked there for about 2 months, was tasked to clean the stole in the white fur room using a special machine. Instead, he wrapped it around his body under his coat at the end of the day and pinched it. It was never recovered, although he was later convicted for a completely different theft. Mrs. Morris sued. There was obviously no point suing the employee Morrissey. He would have no money with which to pay her, and we can infer he was likely in prison anyway. So she sued C.W. Martin and Sons, arguing that they were vicariously liable for their employee. It was established law that an employer was vicariously liable for those things done by an employee in the course of their employment. However, it had long been understood that if an employee did something completely inconsistent with their employment, the employer would not, under those circumstances, be liable. That seemed to change with a case called Lloyd against Grace Smith and Company, where the employer was held liable for the employee's theft of title deeds. Lord Denning set out to clarify the law, stating that the nature of the liability depended upon the precise duty that the employer had agreed to. He said, "When can it be said that the dishonesty or fraud of a servant done for his own benefit is in the course of his employment? If the employer is under a duty to use due care to keep goods safely and protect them from theft and depredation, he cannot get rid of his responsibility by delegating his duty to another. If he entrusts that duty to his servant, he is answerable for the way in which the servant conducts himself therein. No matter whether the servant be negligent, fraudulent, or dishonest, the master is liable." This case teaches us about the vicarious liability of a corporation or an employer for employees. If the corporation or employer has taken responsibility for the goods of a third party, it is responsible for keeping those goods safe. And so if an employee harms those goods, the employer or corporation will be vicariously liable.